Hello again, and in this video, this is an important one. I want to talk about how, if you want to, you can give someone else the power to alter your heir's interest in your estate. So I'm Paul Rabelais. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. This is really a married couple issue. If you're married and you're watching this YouTube video by yourself, you may want to hit the pause button and say, honey, come over here. I got something I want to show you. I think we ought to watch this together. Because this is all about how married people leave their estate to their spouse. You may think it's simple, but really there's three options, and I want to go over those options. Because I've been helping families and couples through this, thousands of couples, thousands of people, thousands of families, and sat across the table from those couples. And I've never in my 29 years heard, let's take a husband for example, because most husbands think they're going to die first because statistically women live longer. I've never heard a husband really put it to me this way. I've never heard a husband say, you know what, Paul, my wife and I, we raised three fantastic children, and we worked hard. I worked in a job 40, 50, 60 hours a week to provide for ourselves and our children, and even worked really hard to try to put a couple of dollars away so that I can make sure my family has something to remember me by, and maybe make life a little bit easier for them with all of the hard work that I've put in for my family. And Paul, it would be perfectly fine with me if, because I'm going to die first, if after I die, my wife meets some young Studmuffin and then just leave everything that I worked for to that Studmuffin when she dies, totally excluding my children. Never heard anybody, really quite put it, that way or that tactfully. So that leads into the really three, and really this third option is the focus of this video, and I really haven't talked about this third option in any of my prior YouTube videos. So kind of pay attention when we get to the third one. That's going to be the one that just may be right for you and your spouse. So let's get into the three ways married people can leave their estate to or for their spouse. The first one, pretty easy. It's like what I just said. When one spouse dies, it all belongs to the surviving spouse. Surviving spouse can leave it to whoever they want to, including, quite frankly, a new spouse that their surviving spouse gets. But nonetheless, some people are comfortable leaving their estate 100% to their surviving spouse, either because they don't think about it, or they just are confident that their surviving spouse, no way are they going to leave it to anybody other than our children. And in many cases that's true, but crazy things happen. So the first option, just all to the spouse, and in many cases it does wind up going to the children, but sometimes either the surviving spouse intentionally leaves things to people other than the children when the surviving spouse dies, or maybe unintentionally because that surviving spouse got dementia or Alzheimer's and was influenced and signed something that is difficult to undo later, and we've all heard stories about that. So that's the all to spouse number one option. The second option is where a husband, for example, he says, when I die, my estate is going to go in a trust for my spouse and my kids. And my spouse can get all of the income from that trust that holds my estate, and my spouse can get that income off of those assets for the rest of my spouse's lifetime. And maybe even that trust further provides that if the surviving spouse needs to use the principal of the trust for their typical standards of health, education, maintenance, and support, it's okay if the surviving spouse uses some of the trust principle or all of the trust principle for the health, education, maintenance, and support of the surviving spouse. In fact, I'm going to link you to a video that talks about that HEMS, H-E-M-S standard. But then under this option two, when the surviving spouse dies, what's left in the trust that holds the assets of the first spouse to die, those must revert back to the heirs of the first spouse to die. And let's say that husband had 3 children, and the husband's trust says that when the surviving spouse dies, what's left in the husband's trust must revert back to the 3 children equally. That's what he wanted. So that's option 2. That's an option where you're providing for your spouse, but you're also protecting your children's interest, because the surviving spouse can't redirect those trust assets to anyone other than those 3 heirs of yours, those 3 children equally. So that's an option. That's also very common. And then there's a third option, which is kind of a combination of the two. And it has to do with a special provision. And I'm in Louisiana. I'm a Louisiana lawyer. Other states are going to have similar laws, but the wording of our Louisiana Trust Code article related to this is unique to Louisiana. But I'm going to tell you what many other states have, the equivalent of that, towards the end of the video. But in our trust code, it says that, let's see here. It says this is where a husband or a wife, if whoever dies first, but I'm using the husband as an example. This is where a husband says, you know what, I'm going to leave my estate in a trust for my spouse, and my spouse can get all the income off of it. And if she needs to use the principal for her health, education, maintenance, and support, she can. And when she dies, it's going to go to my 3 children. But I want to give my spouse the authority to modify the interests of my children or of my heirs, so long as she doesn't so long as no one's interest that is affected is anyone other than our descendants, our children, our grandchildren. So let me kind of go through the provision, then I'll talk about it in layman's terms. So it does say a trust instrument may authorize a person who is in being on the date of the creation of the trust. That's where a husband can authorize his wife to modify the provisions of the trust instrument in order to add or remove beneficiaries or modify their rights if all of the affected beneficiaries are descendants of the person given the power to modify. So what all that means is a husband can say, I'm leaving things in trust for my wife. When my wife dies, I want my trust assets to revert back to my kids. But if my wife wants to modify this who gets my trust when she dies provision, she can do it, but still all of the assets have to go in some form to our descendants, our children, our grandchildren, our great-grandchildren. So that might be applicable, let's say, because you never know what's going to happen from the time the first spouse dies until maybe years or decades later when the surviving spouse dies, and a child of the first spouse to die or a child of that couple, might get on drugs, might go to jail, might do something where he or she deserves not to get anything after both spouses pass away. So some couples are comfortable with this. I'm going to leave it in trust for my spouse, and if my spouse doesn't change anything, it's going to go to our children equally when my spouse dies. But after I die, if my spouse wants to change that ultimate disposition, as long as the entirety stays within our bloodlines, my spouse can change that ultimate disposition so it doesn't go to the 3 children equally, as long as it goes in some form to our descendants. So that's kind of maybe a best of both worlds in some circumstances. It's like I'm leaving it to my spouse, but I'm making sure that my spouse doesn't leave it to my spouse's next spouse or to some other person. Everything's got to stay in the family. Similar to what other states have, and we don't have it, is this limited power of appointment. So it's similar to that. We just use different terms. Our terms are delegating the right to modify a trust instrument within certain limitations. So that doesn't apply in every trust, because my point here is it only applies when the trust instrument allows it, because that's the very first words of this trust code provision. A trust instrument may authorize a person to do all of those things. So just wanted you to be familiar with the concept that, that married couples, they need to have an informed discussion about how they're going to leave things to each other. People are living longer, surviving spouses are living longer. Some of them are getting, demented and Alzheimer's and getting influenced. And I read all kind of stuff today on scams for the elderly. So you got to be careful when you're setting this stuff up. So that the overall family is protected and things are going to go how you'd want them to go, in spite of outside influences trying to do something that messes up the overall plan. Okay, real important that you do slam the subscribe button and the notification bell so you don't miss anything, and then tune in every 10 a.m. Central Time every morning. New estate planning educational videos. YouTube really likes it when you hit the thumbs up button. That's phenomenal. And then any comments you have below or right down there, that's where they go. The best ones are, proofread and, fairly grammatically correct. And don't ask me for specific legal advice, because I just can't give it in a comment like that. So anyway, hope that helps with some of you married couples. I think that decision on how we would leave things to each other often gets overlooked because you go right to the after we both die decision. But what happens when one spouse dies is really critical, and you got to address it well on the front end. All right, we'll see you tomorrow.